Hello, everybody. My name is Brian Nates. I am the president and the founder of Family Legacy Docs, familylegacydocs.com. We created this platform really to help streamline a process that is so important. Familylegacydocs.com was created to be a platform to help you literally streamline a step-by-step process to put together your will, your trust, your power of attorney, your healthcare directives, your advance directives, everything you need for your legacy. We come alongside you. We utilize the platform again, so it's a step-by-step process, making it easy, making it affordable. You don't have to pay the ridiculous amounts that firms charge to do this. So we created this platform once again to come alongside you, make it easy and simple, and help you plan your legacy because it matters. But it doesn't have to cost you a fortune. You're going to hear from one of our teammates. His name is Scott Nelson. He saw Family Legacy Docs himself. He is an attorney, and he fell in love with what we created. He's going to take you through what Family Legacy Docs is, why it's a good tool to use, how it compares to other things that are out there, and really the Family Legacy Docs difference. Go ahead, watch the video, and know that we're here to help, and we look forward to helping you plan your legacy because it matters. Thank you now.
Hi, my name is Scott Nelson. I am an attorney from Glastonbury, Connecticut. And today we're going to give you a little education about what your estate planning document options are in the marketplace. We're going to start with your lowest cost options and then show you your highest cost options, and then where Family Legacy Docs fits between those two and how we think it's going to be your best long-term overall value for you and your family. So on the left side is your lowest cost plans, and we call those your do-it-yourself plans. And one of the biggest problems with those is the fact that you have to do it yourself. And you'll find these everywhere. They're at Staples, Office Depot. They're all over the internet. When you have to do it yourself, you're faced with some issues. Because if you get to a point in that interview process and you have a decision you have to make and you're not sure it's going to be the right one, typically they give you a little pop-up box. And that really doesn't answer the question either. So they have an 800 number for you to call. And of course, you're going to call it. And then they have attorneys standing by to try to upgrade you to a more robust plan. So that's typically what you're faced with. They provide three basic documents. One is a simple will, which means it isn't a bad will. It just does not involve a trust. And typically that says, no, if the husband predeceases the wife, then everything goes to her. If the wife predeceases the husband, everything goes to him. And if they both go together or at the second death, then everything either goes to the children or whoever else they want their assets to go to. The other documents that they provide is a durable power of attorney, which basically is a document that allows someone to act in your behalf. So if you're on vacation on a iceberg cruise up in Alaska and you need something signed in your hometown, whoever has that document can sign on your behalf as if you were there in person doing it. And the other document is your healthcare power of attorney. So if you get in an accident and you're unconscious and the doctor needs your consent to do some operation to make you better, the person who has that document can give the consent needed in order to make sure you're going to be okay. But one of the other things we have found is that the sale of your information is rampant with these plans. And so when you get involved and sign up and get the plan, there's a little user agreement. And when you sign that user agreement and you click that I agree box, typically on page like 36 of that document is a statement that says, you give us permission to share your information with our affiliates and partners. And who's that? Well, that's anyone who will pay for your information. And so you bought a program that you've just allowed people to know everything about you. And they profit from that. So they know your name, your address, your email address, your phone number, your assets. And so that has been a really big discovery. And I would discourage getting involved with those plans at any cost. Now, your highest cost plans are going to be by a full service law firm. And there you're going to have an attorneys, first, second year associates who just basically graduated from law school, paralegals, and everyone's going to be there to be able to answer your questions. So you are not going to make a bad decision in your plan itself. And they price these plans either in a package price or by the document, or they'll charge you by the hour. But they're not stupid. I mean, they're going to price it competitively, or at least find out what your pain tolerance is for paying for your plan. And so they will give you a price. And they really do, though, have a hidden agenda. And that is they want to be the trustee or successor trustee in your plan. They want to provide the annual reviews. They want to do the probate administration. And they also want to do the trust administration for your family. And those all give the law firm kind of a lifelong annuity of which they get paid hourly in order to accomplish what they're supposed to in your planning process. They're going to price this anywhere from $4,000 to $8,500. That's the average. My father spent about $12,000 on his plan. My twin brother, who had gone through a divorce, who was single, paid $7,000 for his. But I think in the marketplace, you're going to be somewhere between $4,000 and $8,500. But know full well that they really want to be in your back pocket for the rest of your life. If I had to choose between these two, then I would always go with the full service law firm. They're going to be able to answer your questions, help you through the difficult answers to some of the questions you might have, show you what your options are. And so you're going to get a document that's completely valid and works for you and your family. Family Legacy Docs fits right in between those two. And we provide the same or better documents than the full service law firm. You might ask, well, how is that even possible? What happens in a full service law firm is that the estate planning department is kind of on the lowest tier of revenue generation for the law firm. So a lot of times you have the first and second year associates, the paralegals, cut and pasting word process documents that fit the needs of that particular client. And a lot of times clerical mistakes happen. You'll have property from the husband going to the wife at the first death. And then if there's a wife that predeceased the husband, those two names get mixed up. Psychologically, what happens is if you're in a big hurry, which is often the case, then you are assuming that the language in that paragraph is perfect because you've read that document so many times. And sometimes those little things just don't get picked up. And so with our process, that cannot happen. So it is a software-based process. So you will not see paragraphs refer to articles or paragraphs of another document that don't exist in your document, and you won't have those common clerical errors. Our product is valid in every state, and it's attorney assisted. And overall, we think it's going to be the best long-term value for you and your family. Now, we provide 6 major documents in our plan. The cornerstone of our document package is a revocable living trust. And a revocable living trust is just like you, but on a piece of paper. You can change this document every single day. And that's why it's revocable. You are actually saying, what is going to be the best financial decision I can make for each beneficiary? It avoids probate. We'll get into that a little more specifically later on. And it saves you thousands of dollars. And it's also a private document. Nobody will know what your assets are, who they're going to, and when they are going to get it. The Revocable Living Trust has all these options available. I'm not going to go into each one of those, but let me just say that it can be individually customized for every single person in your family. So that gives you a lot of options and a lot of flexibility because you never really know how things are today or how things might change in the future. And since you can change this document anytime, it gives you the opportunity to make sure that you're looking out for the best interest for everybody. The other document we provide is a certificate of trust. When you fund this trust, which means retitling property in the name of the trust, then your bankers, your brokerage people, they're all going to request a copy of the trust. You've spent all this time and money to get a private document, and now you want to hand that over to your banker or your broker? So what a certificate of trust does is it avoids that disclosure. It's a one-page document, and it says this trust exists and it's validly executed, so you don't have to worry about them disclosing everything about you and your family. I will also say is a lot of times this document is not provided in a lot of law firm packages, and I witnessed this for the first time myself. My father died recently, and he, like I said earlier, he spent $12,000 on his plan. And when I went to get the certificate of trust, the law firm said, "Oh, you have to sign an engagement letter." And I said, "Well, why?" I said, "Well, you're requesting a new document." I said, "Well, don't you provide that to your clients?" And they said, "No." I said, "Okay, well, I'll sign the letter, but what are you going to charge me for the certificate of trust?" And they said, "Well, I'm a senior partner. That's $660 an hour, but we'll have one of our associates do that. We only charge $330 for them to do the work." I said, "Okay, how much is it going to cost?" And they said, "Well, we expect it's going to be 2.5 hours." And I couldn't believe it. They want to charge me $850 that took me 12 minutes to generate on my own. And we provide this as part of our whole package. So you do not have to go through that exercise like I just went through. And I didn't end up paying them, and you shouldn't have to either. We also provide a last will and testament, but this will is a little bit different. It's a pour over will, and it's beautifully synchronized with your revocable living trust. And basically what it says is that to the extent that I have not retitled property in the name of my trust, then whatever I have at death pours into my revocable living trust, because I'm using that as a document to distribute my property. So there isn't anything slipping through the cracks, and it is a very nice, simple document that's sophisticated to make sure everything is coordinated in your plan. We also give you the financial power of attorney, the healthcare power of attorney, and a living will. And the living will simply says, if I am brain dead and there's absolutely no possibility of me coming back and enjoying the life that I once led, does the family have to pay for the expenses of keeping me breathing on a machine or having a drip in my arm to feed me? Can't we just let me die in a dignified way, maybe giving me some pain medication, but in essence allows the family to pull the plug? So we provide that document. I think it's a very thorough document, allows you to maybe make organ donations if you wish to, but all of those are included in our package. In addition, we also have several features and services. We have a document vault that's open 24/7. So you can put your family photos in there. You're going to have all of these documents included, but you can also have letters that you wish to give to other family members. You can put personal videos in there. And we also have an online funding kit. And probably this is the most important thing in the whole process, because psychologically, when people sign their documents, most people say, "Okay, I'm done." But what really needs to happen is you need to fund the trust. In order to make that easier for you, we have this funding kit. It outlines all the available assets that you may or may not own, and then it gives you the information you need to actually retitle those assets in the name of your trust. Once that is done, then you can have complete peace of mind that you have a great package. We also give you the unlimited funding letters that you would need for that process. So generally, property passes 4 ways. You have your spouse's assets, you have your jointly owned property, you have beneficiary designations like life insurance policies, 401ks, and you have your assets. At your death, everything that's in your spouse's name stays theirs. And typically, they're the jointly owned right of survivorship recipient. They're also typically the beneficiary under your retirement plans and insurance policies. So it's only your assets that are distributed through your will, if you have one, which then goes through probate. And then after probate, your assets are typically distributed to your spouse, your children, charities, or all of the above. If you're in a situation where you don't have a will, your estate will still go through the probate process, but it'll be a little bit more complicated because with probate, if you don't have a will, then the probate judge, and you have to get on the docket, then appoints an administrator who performs the same function as the executor under your will. And they just are the people kind of coordinating all the efforts to make sure you get through this process. And the administrator then has to pay a bunch of fees. That's set by a statutory fee schedule by the court. You have attorney's fees. There's a bond that has to be posted and paid for. These are all expenses that come out of your estate. Then you have to take an inventory of your assets. Sometimes that requires an appraisal. Then publication has to take place. So if you have a will, then some places will even publish the whole will. If you don't have a will, then there is a death that's reported and publicized in newspapers and other places. And then there has to be a payment of all the taxes. And then after that takes place, then there's a division of the assets. The difference is that if you have a will, you kind of decide who's going to get your assets. If you don't have a will, then the state is going to determine based on a formula who receives your property. And it may not be who you would like that distributed to. So in a typical situation, you would have your spouse and you'd have your children. If they're minor children, then there would be a guardian that would be appointed for the person to take care of the child. And if that person wasn't really financially astute, sometimes there'd be a guardian of the property appointed for the children. And then you might have others, and I'll get into that in a second. But when you have a surviving spouse, the states will determine that that person gets the first $10,000 to $100,000 right off the bat. And then everything's split 50-50 with the children. And a lot of times the states don't like children owning real estate because they don't have the income to maintain the property or pay the mortgage or insurance. So the real estate would go to the surviving spouse, but it puts the spouse in a horrible position of having to borrow from the children in order to make the mortgage payments and do the maintenance. So it can be a real mess. And then if you have minor children, those assets that are set aside for them have to be in trust until they turn age 18. And that whole time, there has to be annual statements provided to the court to make sure that the money is not being spent unnecessarily. So this illustrates one problem in that the spouse doesn't have the money they typically need to maintain everything. And then at age 18, I don't know what your money management skills were like when you turned 18, but I probably would have bought a car. And that may not be the best long-term financial decision for the money for that person. So those are a lot of issues that come up. And here's another one that comes up when there is publication. When you die, there's a notice that's published in the papers and the internet saying that you've died. And just for an example, let's assume that there's Billy Bob who lives in a van down by the river, and he goes, you know what? I think John owes me some money. So he makes a claim against the estate. The spouse may say, we've never heard of that person. We have no idea who he is. But the probate judge has to take that claim in, and there has to be an adjudication of whether that is a real claim against the estate or not. And this puts the surviving spouse in a horrible position because sometimes attorneys will say, look, it's going to cost $12,000 to litigate that claim against the estate, and they're only asking for $8,000. So do you want to spend $4,000 more to prove you're right, or do you just want to make an offer and let them go away? So a lot of times they'll say, well, look, we'll give you $2,000, just go away. But there's an additional expense against the estate, and that happens all the time because there's a publication of death, and through the probate process that's unnecessary. The bottom line is probate takes anywhere from 6 months to 5 years in some cases, and that's if there's litigation. It's really costly. It can cost anywhere from $3,500 to $12,000 in some situations. I unfortunately have a probate with my father's estate, and it cost me $20,000 and was completely avoidable. And that's because he bought a condo late in life, was trying to decide who was the best person or people to own that after his death. So he never got around to putting that in the name of his trust, and it didn't get done. So that was very costly, and it's completely unnecessary. And of course, there's the lack of privacy. So you've died, and let's assume 10 years later, your spouse dies. Got some bad news. Their estate goes through a second probate. So all those expenses that we just talked about has to be incurred again at the second death. So we don't want to have that problem for you and your family. So this is our plan, and this is how it should be structured. You take your assets and you retitle those in the name of your revocable trust. They don't go anywhere. Think of it as taking your property from your left pocket and putting it into your right pocket. You are the trustee of your trust during your lifetime, and it just operates as you would operate. It just has a different name. And then at death, your property can be distributed immediately to your spouse, to your children, to charities, all of the above, without going through the probate process. By getting just the death certificate and providing the certificate of trust to the organizations to make those distributions possible. Way less costly and completely private. So imagine what it's like for your family members. After your death, they have to kind of go through and find out where all your assets are. So what was in the savings, checking accounts? Were there several accounts? Where were they? How much was in there? How was the account titled? Same with the home residence. Regarding investment accounts, a lot of times the statements aren't distributed but semi-annually or even quarterly. And so it might be 4 months before you see a statement and not even know that that account exists. So you have the opportunity during your lifetime, which may take maybe 20 minutes, to list all these assets in our funding kit, be able to take care of this while you have all the information instead of taking months and months for your family members trying to determine how it was structured, who owned it, and how much was in there. So it reduces the time and costs by streamlining distribution tremendously. So everyone has an estate plan. It can be either your plan or the state's plan. So if you have any questions, send us an email, say this is my particular question, and we'll get back to you as soon as we can.